now. Good afternoon, ladies and gentlemen. Distinguished excellencies, we'll be starting the fourth and last session for the Cyber Stability Conference 2023. If I could please have your attention. My name is Mudehi Makumani, and I work for the UN Institute on Disarmament Research, UNIDIR, based in Geneva. And if you're still here at this time of day, it means you really are enjoying this conference. Thank you so much for staying. And for our online participants as well, thank you for staying. This fourth session will be focusing on peaceful settlement of disputes, UN Charter Chapter 6. And after a long day of discussions, I think this is a good way to wrap up this conference. I am joined by a high-level participants, and I will start on my extreme left. I'm joined by Professor Haja Goldich, professor and member of the African Union Commission on International Law from Tunisia. And then on my immediate left, I'm joined by Mr. Harry Ormsby, legal advisor, Foreign, Commonwealth and Development Office of UK. On my right, I'm joined by Mrs. Ricarda Christiana Chanda, second Deputy Permanent Representative, Senior Legal Advisor from the Permanent Mission of Switzerland to the United Nations. And on my extreme right, I'm joined by Deputy Permanent Representative to the UN from Pakistan. And these four panels will be joining us for this last session. And as the day has progressed, you've seen the general order of how things have been run, and I will follow the same order. And so we will start with a general overview presentation for 20 minutes from Professor Haja. And Professor Haja, over to you.
Thank you so much, ladies and gentlemen. Good evening. Allow me first of all to thank and to congratulate the organizers, UNIDIR, for this very high-level conference. Thank you for the invitation, and thank you for all the panelists and the different participants, because I learned a lot since this morning. And also the number of the followers is, since the morning, it is huge, and this shows how much this topic is accurate, it's important, and above all, the importance of international law in the field of cyber security. This conference is called Cyber Stability Conference, and I asked myself how to enforce, how to implement stability in a field where there is no stability. As you know, ICT environment is changing very quickly. The first generation of computers and communication, you saw this machine just in front of our conference room. It's big, it's huge. Compared to our smartphone, this gives you an idea that the evolution of technology is very fast. However, the evolution of the law is very slow. And that's why, next slide please, we have to ask ourselves a question: how the international law can be implemented in the field of cybersecurity will be based in this introduction on definitions, ICT environment, what it does refer to, and we will focus on the importance of the peace and settlement of disputes in the cyberspace and in the cyber conflicts. My first part will tackle the question of the principle of the peaceful settlement of disputes, and you know that this is an obligation regarding the United Nations Charter, and you will see that this evaluated, it becomes an obligation in 1945, and I will focus on the legal instruments, the doctrine and the jurisprudence, to show you how we evaluated with these obligations, and above all to know about the means, the tools of these different mechanisms or tools of the Pacific dispute settlement. After that, in the second part, we'll together see what is the element of peaceful settlement of disputes discussed by states and the national position of the states. Next slide, please. So I will not be very long with the introduction. Just let me tell you that about my references. I was focusing on the United Nations, different publications. I saw here very useful publications, and I worked on the reports of the group of government experts, especially the last one, A76-135, the important role of UNIDIR in such field. Next, please. After that, I focused also on the doctrine. There is not a lot of scholars who wrote on the link between the peaceful settlement of disputes and the question of cyber disputes. However, I found a very next important colloquium conference which was held in Great Britain in 2021, and it was about the peaceful settlement of cyber disputes, and a lot of very eminent scholars have very good papers, and everything is online. So in my introduction, as I told you next, concerning the definition of the different tools and means and the expressions. So, as you know, the use of information and communication technology is really increasing a lot over the years, and this have an impact on international law, but also on peace and security. And again, I recall just what said Professor Huang, the first provision in our charter, the first paragraph of the first article is about peace and security, maintaining international peace and security. This is the soul, this is the scope, this is the main important principle in all the charter. And if you can just number and see how many the expression of peace and security is there, you can understand the importance and the equity of peace and security of the world. And that's why, as I told you, our ultimate maybe objective is peace and security, and we need to know how, what are the tools so that we can have peace and security. After that, in this definition, we also have to comply with the important rule of United Nations Charter, as it is the main important source of international law. This is our Bible as internationalists. So we'll provide an overview of the existing doctrinal understanding of the different principles and obligations of ICT environment and its consequences. Next, please. Concerning the cyber operation, I will skip that because we said that since the morning. And also the ICT environment, we know it does refer to what, but we have to focus on next. We have to focus on the avoiding of conflicts and how. This is a very important idea, and this objective, again, is to maintain stability, peace, cooperation between nations, and to avoid war, to avoid conflicts, to avoid the use of force. The next slide. And as I told you, the part one will focus on the obligation, the principle of peaceful settlement of disputes. And as I told you, I will tell you how we go from just a wish to an obligation. So maybe when we go from a historical point of view, the first stage was the conferences of 1899 and 1907. And in these two conferences, as I told you, we are dealing with very strongful states or empires. So we cannot oblige them and tell them you must. And that's why in the text you can just put, it is better to go to the peaceful settlement of disputes. However, after that, in the second step, and we have the next, please, we have the second stage, which is the League of the Nation, and we have this Charter of the League of the Nation, in which we have the first recognition, universal recognition of the peaceful settlement of international disputes. But in that time, we didn't enough obligation. So we did not tell you they shall, they must. It is just, again, it is better for the different states to go to this principle. And finally, with the United Nations Charter, and this is the déclic, we have two war, and we have crimes against humanity, war crimes, we have Hiroshima and Nagasaki bomb, and no more crimes like that. And it is compulsory now with 1945 text, which is our charter, and it does not change 75 years or more till now. And we have, again, a lot of questions that can be there if the existing provisions are enough for the cyber security, or we need new rules and new procedures. This will be a little bit the question in all our presentation. So here in this stage, we have very, how to say, it is very coherent in the next slide, the two articles, the Article 2 and the Article 33, and you can just read the Article 2.3 in parallel with the Article 2.4. We cannot use force, so what we can use, we have to use the peaceful meanings. And as you can see, shall, must. So here it will become an obligation. Let's next, please. As I told you, this was after that confirmed by two other texts, the 1970 UN Declaration on Principles of International Law concerning friendly relations and cooperation among states, and in which we can see that this is an obligation for the states. And after you have the Manila Declaration of 1982, and it is called the Declaration on the Peaceful Settlement of Disputes. And in the Manila Declaration, you can find the definitions of all the different tools, all the different means in this toolbox of means of peaceful settlement of disputes. However, the problem of cybersecurity, again, is a field which is very ambiguous. So the question, again, can we go further with all these traditional ways and to implement them in a very specific, very technical, highly technical, but very difficult and a new field, which is the cyberspace. So as I told you, we have to see the article next, the Article 2, paragraph 3, in correlation with the Article 33. Next, please. Just 1 second. Back. It is important also to the report of the UN group of experts said that the international law applies online, and it also does apply offline. And we can see that in all the recommendations, it is very important to tell that the dispute settlement, peaceful dispute settlement, apply also in the cyber security, and you will see that this is also the position of the states. The next, as I told you, we can just see what are these means, what are these tools in the Article 33, which should be the explanation of the Article 2, paragraph 3. In the 2, paragraph 3, it is thus a composition. International disputes should be settled by peaceful means. What are these peaceful means? You can go through that in Chapter 5 next, which is the introduction is the Article 33, and you can here have a bulk or a huge bulk of different tools and means. Just we can remind that the Chapter 5 is coming just before the Chapter 6 and 7. And in this chapter, we have this question of 5, the Pacific settlement of disputes. It is even before the Security Council role in the breach of peace, in the threat of peace, etc. So it's important, again, to begin with the beginning. And the beginning is all these bulk of very important tools. If you can notice, we do not have any hierarchy in the tools, and we have no obligation to choose any of them. There is a freedom for the states to choose any of it. And you can see here in the article, first of all, the states seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their own choice. So in this paragraph, you cannot see any obligation. The states are just free to choose whatever means tool they prefer. There is no hierarchy. If just you can follow the scholars, they put two bulks. There is a bulk of the means which are called diplomatic means. They are not binding. And you can put in them the negotiation, inquiry, mediation, conciliation, and resort to regional agencies or arrangements. All of these tools are not binding. This is what is called the diplomatic tools. The second bulk will be the judicial tools, and in it we can put the arbitration and the different courts, the judicial settlement. That means that on the contrary of the first bulk of tools, in the second one, the last resort jurisdiction will be binding. And this is a little bit the difference between diplomatic tools and the judicial tools. Again, the second bulk is binding, the decision is binding, and it should be implemented. However, again, this is a very important remark. Last slide, please. We do not have any hierarchy. We are not obliged as states to choose one of these different tools. Moreover, if one just failed, we have to seek another one. Again, just pay attention with this very important idea we have in all the hypotheses to avoid the use of force. The use of force, and this is what's said since the morning, is allowed only in two very, it is not extensive, it is just very narrow interpretation of the two exceptions. The exception number one is the legitimate defense. The exception number two is the mechanism of the Chapter 7 Security Council and in case of the threat of peace and security or breach of peace and security. And as I said, you cannot go to the use of force unless you go through all this peaceful meaning. This is a central idea, and we can transpose this idea in the field of cyberspace. So in the next slides, we can just discover one by one the definition of these different means, and at the same time try to find if we can see in the cyberspace field that it is accurate and it is relevant. Concerning negotiation on the light of the affair of Mavromatis, 1924, and this was confirmed by the affair of Notre Dame case in 1955. The court said that negotiation is to be conducted in good faith and that it is a complementary norm on good faith that applies in case of disputes. And they said also in these cases that this is a more flexible, the less complex and the more flexible, the more easy way to settle disputes, it is negotiation. If we compare negotiation to the other diplomatic means of settlement of disputes, peaceful settlement of disputes, negotiation is between the parties in the dispute. The other ones, you can find another third party. So again, negotiation is really the easiest part of diplomatic means, and in general, it is not binding. As I told you, all these bulk of means are not binding, and it is the first thing to which we can just imagine to be relevant in the cybersecurity field. However, the complexity of evidence and the attribution with regards to cyber disputes is a little bit complex, and that's why it is a little bit it is not easy to find that negotiations are successful in the cyber security field, and that's why on the light of the scholars, they put some recommendations. For example, they imagine creating a global center for cyber attribution and forensic evidence that might support each process between the states, and such center can be just distant and can just give the possibility to put an end to tensions in the cyber security. The next mean will be the question, next slide, will be the question of good office and mediation. In general, in the history, who do the good offices and mediation? It can be a king, it can be a queen, it can be a very high eminent personality in the diplomatic arena. But nowadays, it should be just an expert or a highly important personality in this field, or even a commission. So these are, again, not binding. The solutions are not binding. The good offices and mediation give you a solution that is not binding. And on the question of cyber, the cyber disputes are usually closely linked to attribution, forensic evidence again, and due diligence, and states' failure to provide it. So maybe we have to prove the most effective measure of settling international disputes when it comes to those related to ICTs, and this is a little bit difficult. That's why scholars have some recommendations in the next slide, and they said maybe we have a lot of ICTs, and maybe we can look to the Cyber Peace Institute, we can look to dedicated cybercrime and cybersecurity sections within Interpol so that they can give their expertise in this field, Internet cooperation for assigned names, numbers, Internet Society, Internet Engineering Task Force, etc. So this may give plus value in the domain, very complicated domain of the cybersecurity. The next mean, diplomatic mean, will be the inquiry. And in general, inquiry, it is based on international fact-finding commissions like the one of the Article 19 of the Protocol of Geneva Conventions in IHL. So the Commission of Inquiry, the same thing, the same philosophy. They can give you a solution, but this solution is not binding. And in the commissions of inquiry, it will be rather the perfect fit for cyber disputes. As I told you, when we have commissions of highly technical expertise, it is better than people who are just coming from very different sides and they are not mastering the piece of high-level expertise of these commissions. So it's a good idea, according to the scholars, to go through these commissions or these inquiry commissions in the field of cybersecurity. Next slide, please. Concerning now the recommendation, so this is a little bit an idea of example to what we can refer, ICANN, ISOG, etc. And this is why the recommendation of scholars give us the importance of feasible technical solutions, which is based on highly technical commissions. The next mean will be, next slide, will be conciliation. And again, the conciliation is a mean that is not binding. Conciliation is designated to address both legal and factual questions. And in general, conciliation is done with commissions which are, they can be politicians, but they can be also experts in the field. And it is important to take the appropriate note of the technical expertise necessary to provide conciliation with regard cyber disputes. It can be a good solution in the cyber environment. The next now we can move to the other regional organizations, and this is the paragraph 42, paragraph 1 and 2 of the United Nations Charter that indicate that we can also, for the states, they are free to go to the regional arrangements. However, a very important article 35 and 34 that tell us that the Security Council and the General Assembly decisions have the supremacy over the regional arrangements. Maybe I can just tackle the question of AU, African Union. Next slide. As maybe you do not know, or you know, I don't know, if you have an idea about the African Union framework on the cybersecurity and the cyberspace, I am the chairperson of AUCL, and a lot of people do not know what is AUCL. We are just like the ILC of the United Nations. We are the International Law Commission. We do codification in the field of international law. And even if we have already a very good convention, it is called the African Union Convention on Cybersecurity and Personal Data Protection, signed in 2014, but unfortunately, in the morning, I focused on the number of ratification, and I found only 13 ratifications. That means that this text is not coming into force yet. And I go to the Article 34 of this convention, and concerning the dispute settlements, he said that first paragraph, it is negotiation, and the second paragraph that said in case of disputes, they should go to the other peaceful means. So it is in harmony with the text of United Charter. However, I just need to tell you that within AUCL, our commission, since 2022, we have a special rapporteur, who is the Commissioner Mohammed Hilal from Egypt, and he's dealing with a new study on peace and security in the cyberspace, proposal for an African contribution to developing the rules of international law governing cyberspace. In the morning, I had a very important conversation with Mrs. Moliehi, and she told me that it is a pity that the African Union position is not very deep. We have very superficial provisions. We do not see a lot of experts, even if they are existing. We have very good specific personalities in Africa and in African countries in the cyber security. However, I'm aware that we are not at the same development of cybersecurity like the powerful countries and the developing countries. So that's why these questions, we are not really very developing in such questions. They are not really priorities for Africa. However, again, networking is very important, and we can just call the personalities and the people, scholars or diplomats or whatever, just to tell you that in this year, the Peace and Security Council of African Union has this topic in his agenda, and they will deal with the cybersecurity. Maybe in April, I think, there will be a very important webinar on cybersecurity, and maybe we can just cooperate together, because your expertise and your skills and all these conclusions of this conference will be very important and useful for Africa and for the African Union Commission. How much time I have? Still 5 minutes. I will have to go very quick now for the next ones, which are the judicial means or tools. Next, please. So concerning the judicial means of peaceful settlement of disputes, I told you we have two means: arbitration and the judicial or the courts. So arbitration, you have the jail treaty between Britain and America, and the first case, which is the Alabama case, gave us the first important case of arbitration in the international law. And since then, we have the evolution and the very important role of arbitration. We established the Permanent Court of Arbitration after that, and it does still exist. However, it is not permanent, even if it is called Permanent Court of Arbitration. I mean, next slide, I mean that it is not composed by personalities or permanent judges. You know, it is a list. It is just a panel of judges. It's a list. Each country just give a list of judges, and after that, when there is an affair between two states, they will just choose the judges from this list of arbiters. And again, this is a very important field for cybersecurity. Arbitration was very famous at the beginning. However, when came ICG, nowadays arbitration is in the field of finance, in the field of economy, in the field of IP law, in the field of sports, and maybe in the field of cybersecurity it should be very interesting. I didn't find any cases on the cybersecurity in front of the Permanent Court of Arbitration, but again, on the basis of the scholars and the doctrine, they said that this is a very good issue for settlement. The next, please. Concerning now the permanent international courts, we have the Permanent International Court of Justice, and after that it was replaced by the actual ICG. The ICG is a very important tool to make a point of for the settlement, for the disputes, and it is a very high-level expertise judges, 15 persons elected, and not only the ICG since its creation. The next, please, filled the gaps. Really, a lot of things in international law, they were built because of the ICG, including the law of the sea, including the questions regarding IHL, questions regarding human rights, questions regarding different fields of international law, since Nicaragua case, the diplomatic Tehran diplomatic personnel of United States of America and Tehran case, Lockerbie case, really these are landmark decisions, and in each jurisprudence and each affair we have a lot of plus value in the international law. So ICG jurisdiction not only put an end to disputes between states, but also it fills the gaps of international law, but also it gives us peace and security, as said the charter. And if you pay attention, this charter, it has annexed the statute of the International Court of Justice. This gives you an idea how important the ICG is. Next, please. So I will not be very long. You can just, we go through the second part now. It's important now to observe that in concerning, next, please. The conclusion of the first part, it is safe to say that the negotiations, mediations, and good services would be the best suitable methods for peaceful settlement of cybersecurity because they are flexible, because there is a choice, because they are easy and they are not binding. And the second bulk, also it is important, but till now I didn't find any affairs concerning cybersecurity in front of ICG or the Permanent Arbitration Court. The next slide, so it will be now very quick. The second part will be what are the position of the states. I didn't find a lot of opposition. All of the states are really regular and they have the same idea and the same principles. All of them try to tell us that chapter 5 of the 6 of the charter is very important, that the peaceful settlement of dispute is very important, that the states should first of all seek a solution by such means as described in Article 33, that they will choose this means in this toolbox and they are free to do it in the cyber space. Next. Also in the question of the different conclusions, you can see that they said the existing obligations under the international law are applicable to state use of ICTs. So that means that all what we have in this charter is applicable. If you can see the manual of Tallinn, when we just discussed about IHL, there is soft law, there is changing law. They are trying to find new provisions in the question of cyber attacks, cyber security, etc. However, in what I understood with these different conclusions, that all what we have in the charter is relevant in the question of cyber security and the cyber environment. However, we have a second point, which is about the faith, next, the good faith. And all the states said, in general, that it is appropriate and reasonable, available, and feasible steps to be taken in order to detect, to investigate, to address the situation. And they said also that a state should not permit another state or non-state actor to use ICTs within its territory to commit internationally wrongful acts. And maybe this leads us to the question of the responsibility of the states for wrongful acts. Maybe we have to conclude now because of the time. The conclusion, please, the last slide, concerning these different rules. And I just need to conclude and to tell you that these different means and tools are maybe, I just put a question because I cannot just have the conclusion for myself. I just ask the question to all of you. Do you think that we have just to need to amend a little bit to complement the established procedure? We do not have to change anything. The legal instruments are sufficient and we can just implement them in the cybersecurity, or we need, this is the last question, we need a specialized dispute settlement mechanism for the interstate cyber disputes. We need a new bulk of decisions, a new bulk of instruments, new solutions that should be more practical, more technical. As all of you know, this is a very high technical field, and it does necessitate a lot of very technical and highly technical solutions. So this is really a question that we can just discuss in the debate. What do you think about it? Thank you so much.
Thank you so much, Professor Haja, for that absolutely amazing presentation. You've taken us through a really good overview of of how the obligation for peaceful settlement of disputes has evolved, but also how the different means at states' disposal can be elaborated, the challenges in the ICT domain, as well as how different stakeholders have contributed to this, especially with those recommendations. And now we will go to the second part of our discussions, where I'll give the panelists an opportunity to present national positions on the UN Charter provisions related to peaceful settlement of disputes in the context of international ICT security. And I will start with Mrs. Ricarda Christiana Chanda from Switzerland to present her views.
Thank you very much, and a big thank you to UNIDIR for organizing this very timely conference. Also to Professor Guldig for her very clear outline of the law. And I'm happy to be here with my colleagues from the UK and from Pakistan under the competent guidance of our moderator. So in a nutshell, it's a pleasure to be with you here today and to discuss the application of international law in cyberspace. My country, Switzerland, is committed to building and maintaining a free, open, secure, and peaceful cyberspace, and to advancing the recognition, observance, and enforcement of international law in this space. We welcome the consensus that international law, and in particular the UN Charter in its entirety, are applicable to cyberspace. This was confirmed by the GGE and OEWG reports 2021, as well as in the first annual progress report of 2022 of the current OEWG 21 to 25, and also approved anonymously by the UN General Assembly. We also welcome that the first annual progress report recommends focused discussions on international law. Engaging in focused discussions on international law is and has been a priority topic for Switzerland at the ongoing OEWG and its predecessor formats. This long-term effort is part of the Swiss Digital Foreign Policy Strategy 2021 to 2024 and of the recently adopted Arms Control and Disarmament Strategy 2022 to 2025 of Switzerland. As cyberspace is mostly maintained and operated by non-state actors, we welcome the meaningful and broad participation of the multi-stakeholder community. Especially in the field of international law, we can benefit from exchanging views with academic and other experts as we do today and as we will do in the next week to come. Therefore, we very much welcome and thank UNIDIR for organizing this discussion. This is pivotal for all of us. Upholding the international legal order and the multilateral system is in the common interest of all states, of us all. As our foreign minister put it in the General Assembly just over a week ago, even though it feels way longer, it is crucial that we send a strong message for peace and for the respect of international law. And as an international community, we must work hand in hand towards peaceful resolution of a conflict. It is the international legal order that unites us, and as for any other area of interstate relations, this is also very much true regarding cyberspace. Everything possible must be done to meet our obligations under international law in peacetime, to resolve disputes peacefully, and to prevent them from turning into armed conflicts in which international humanitarian law would then apply as lex specialis. This is why today's topic is key to avoid escalation and to build confidence and trust among states. We, the states, send a strong message for peace, trust, and stability if we use ICTs in accordance with the UN Charter and the adopted acquis on responsible state behavior. Then cyber is an instrument for peace. Yet, it also is clear that cyber adds to the complexity of ongoing geopolitical challenges due to its multifaceted nature, even though the threats are not directly visible and tangible, as most of the operations are covert operations. As the OEWG Annual Progress Report 2022 states, the use of ICTs in the context of international security has continued to intensify and has evolved significantly in the current challenging geopolitical environment. There are existing and potential threats to security in the use of ICTs that bear the potential to impact international peace and security. It is in this context that we must redouble our efforts in the OEWG cybersecurity to further clarify how international law applies, notably also the obligations regarding the peaceful settlement of disputes, which is both an obligation on states and at the same time a tool for de-escalation, as we also just heard from Professor Guldrig. Therefore, this topic requires prioritized, focused discussions. When it comes to the Swiss position on peaceful settlement of disputes, we published it in May 2021 in order to further clarify the application of international law in cyberspace. And as Professor Guldrig has also just outlined, the legal obligations regarding the peaceful settlement of disputes are stipulated in Article 2, Para 3 and Article 33 of the UN Charter. The International Court of Justice has generally recognized it as a customary international law, including diplomatic proceedings and arbitration, namely recourse to the Permanent Court of Arbitration or recourse to the International Court of Justice. As a country with long-standing experience and engagement in the provision of good offices, Switzerland is committed to upholding this principle in cyberspace, emphasizing the overriding aim of ensuring that cyberspace is used for peaceful purposes. The UNGG reports 2015-2021 and the OEWG report 2021 then also confirm peaceful settlement of disputes as one of the UN Charter's central principles, which is also applicable to cyberspace. It is an area of international law where states are ready to discuss in more detail what it actually means in cyberspace. We propose to consider the following aspects more closely in such focused discussions as today. First, we could consider discussing not only the legal obligation to settle international disputes endangering peace and security, but also further engage with respect to the added value of the non-binding dimension of peaceful settlement of international disputes in cyberspace. This applies to disputes that do not endanger peace and security. Second, as de-escalation is the overall goal, we could look into how peaceful settlement of disputes could be an alternative to the taking of countermeasures. We see value in doing so in order to avoid de-escalation or to avoid escalation. And third, we could consider how we can address the challenge that a quick reaction to a cyber incident is sensitive in terms of timing and what that could mean for a reaction that favors the peaceful settlement of disputes. This links our discussion to the implementation of the 11 voluntary norms and confidence-building measures, which are both also key parts of the framework for responsible state behavior. Further, implementing these areas help us to reduce risks to international peace, security, and stability, and play an important role in increasing predictability and reducing risks of misperceptions. In doing so, they can contribute to the prevention of conflict. Concrete measures such as the ongoing OEWG's work on the points of contact directory strengthen our overall goal of settling disputes in a peaceful way. And in addition, we should also look at CBMs that have been developed and are implemented at regional level. Professor Guldrig pointed towards the AU. I use the OSCE as an example, which has played a pioneering role in cyber CBMs and has adopted a set of 16 CBMs. One of them, the so-called CBM3, provides for voluntary consultations to help to reduce the risks of misperceptions and of possible emergence of political or military tension or conflict that may stem from the use of ICTs. In order to implement the CBM, a procedure consisting of various steps has been developed. And with this, I close. Thank you very much.
Thank you very much for that. And now I will hand over to the DPR of Pakistan. Excellency Mohammed Amir Khan, over to you.
Thank you, Madam Moderator. Thank you, Chanda, Professor Guldrig, and our colleague from UK for joining us. And thank you to UNIDIR for arranging this very important event today. I'm sure I missed the earlier part, but there have been very fruitful discussions this morning. And thank you to all our participants for being with us. Indeed, the peaceful settlement of dispute is a very important topic, which is very important for all the member states who love peace, who vie for peace, and who seek peace through the UN Charter. The negative use of ICTs to undermine international security through sabotage activities like cyber attacks and cyber terrorism, despite their potential for socioeconomic growth, has raised worldwide alarm. This has led the United Nations to articulate appropriate responses to significant challenges posed by ICTs, while also ensuring that their positive potential and the human rights are not infringed by the desire to mitigate the threats to peace and security. That is why the question of the applicability of existing international law to cyberspace has received widespread and growing support among member states in the past years. The GGE and OEWG on ICTs have both reaffirmed that international law, in particular the Charter of the United Nations, is applicable and essential to maintaining peace, security, and stability in the ICT environment. States have also confirmed that sovereignty and international norms and principles that flow from sovereignty, as well as existing obligations under international law, apply to states' ICT-related activities and their jurisdiction over ICT infrastructure within their territory. More generally, states have also committed to meet their international obligations regarding internationally wrongful acts attributable to them under international law. However, the full extent to which international law applies to ICTs is not spelled out in these reports. Consequently, state practice and their views are not clear in this regard. As far as Pakistan is concerned, it is opposed to the militarization of cyberspace and the use of ICTs for destructive purposes. Pakistan also believes that the principles of non-use of force, sovereign equality of nations, non-interventionism, and peaceful settlement of disputes, as enshrined in the UN Charter, continue to apply in cyberspace as in the physical world. Pakistan also holds the view that, like the UN Charter, the international humanitarian law is also applied in cyberspace. Coming towards today's topic on peaceful settlement of disputes, allow me to make the following observations. The basic framework for the peaceful settlement of disputes is outlined in the UN Charter in Articles 2, 3, Article 11, 14, 33, 34, and 35. This principle has been confirmed by, among others, the 1970 UN Declaration of Friendly Relations and the 1982 Manila Declaration on the Peaceful Settlement of Disputes and the ICJ in the Nicaragua case. As per the current understanding of these principles, firstly, there is no direct obligation for states to choose a particular measure for a given dispute. Secondly, states are not obliged to address a dispute through a mechanism that is not consented by all parties. And lastly, states are required to refrain from any action which may aggravate a situation endangering international peace and security. Regarding the peaceful settlement of disputes in cyberspace, it is crucial to acknowledge the fundamental divergence between cyberspace and physical world. Cyberspace is borderless and fraught with challenges like anonymity and technical and political impediments in view of establishing a mechanism to accurately attribute cyber attacks to their actual perpetrators. Therefore, traditional frameworks of international law, including those related to peaceful settlement of disputes, state responsibility, sovereignty, and non-intervention, were established with the physical world in mind and therefore may not be fully applicable in the context of cyberspace. Pakistan contends that without resolving the challenge of attribution, enforcing international law, and IHL in cyberspace, including the formulation of mechanism for the peaceful settlement of disputes in cyberspace, will remain unattainable. Given the use of cyberspace by both state and non-state actors, the anonymity, given the use of cyberspace by both state and non-state actors, the anonymity afforded by the internet and its transnational character, tracing a cyber attack to its true source can be challenging but also insurmountable. Pakistan holds the view that strong coordination and cooperation among the member states may result in an accurate tracing or IP address back to the origin of the attack. Moreover, Resolving the attribution conundrum is crucial to holding accountable those who violate international law, regardless of whether they are state or non-state actors. Similarly, the nature of disputes in cyberspace will also be different. If we analyze the recent trends, the interstate dispute vis-à-vis cyberspace may include the issues like attacks on critical infrastructure, allowing national internet infrastructure, and utilizing global cyberspace for dissemination of fake news and disinformation, cyber terrorism, the issues relating to data privacy, cross-border data exchanges, and most importantly, the unregulated military uses of cyberspace and related technologies. Considering all these factors in mind, Pakistan endorses OEWG and GGE conclusion, which identifies the necessity for further clarification and consensus regarding how international law, particularly sovereignty, self-defense, non-use of force, peaceful settlement of disputes, and realm of cyberspace should be implemented. For peaceful settlement of dispute, the Security Council under Articles 33, 34, and 35 has competence to intervene in disputes at different stages by requiring parties to seek solution of their disputes by peaceful means of their own choice or to investigate facts. Like the Council, the General Assembly also has competence under Article 14, and it encourages parties to resolve differences by peaceful means. Moreover, the Secretary General has competence under Article 99 to take initiative to peacefully resolve disputes. However, there are two drawbacks in this framework. Firstly, cybersecurity has not really entered into the Security Council agenda, even though the topic of state use of ICT was introduced to the UN agenda more than 20 years ago. And secondly, action on several decisions under Charter 6 depends largely on agreement between the permanent 5 members of the Security Council. Pakistan firmly believes that the best possible way forward would be the formulation of a legally binding instrument that will establish clear standards, regulations, dispute settlement, and enforcement mechanisms. The legally binding instrument shall also define and regulate the usage of cyberspace and shall make it binding for the states to ensure that the domestic internet infrastructure shall not be used for destructive purposes. This legally binding framework shall also provide a foundation for a promotion of international cooperation and capacity building by including education and awareness-raising initiatives. In conclusion, the need for peaceful settlement of disputes in cyberspace cannot be overstated. The absence of regulation and transnational nature of the internet poses significant challenges, and it is essential to develop legally binding mechanisms to resolve disputes in cyberspace. The United Nations Charter provides a solid basis for developing such mechanisms, and the international community must work together to develop a legally binding framework from the peaceful use of cyberspace. We must ensure that the cyberspace remains a platform for communication, commerce, and the exchange of ideas, and not a source of conflict and insecurity. I thank you.
Thank you very much, Excellency. And now I'll give an opportunity to Mr. Harry Ormsby to give the UK's view on this issue.
Thank you. I'd like to thank UNIDIR for organising this conference and for the invitation to speak, and I'd like to thank my fellow panellists for their contributions today as well. Thanks very much. I'd also welcome the focus of the conference on the rights and responsibilities of states under the UN Charter in the use of ICTs. Before I speak to the UK position on settlement disputes, I'd like to say a few remarks about the importance of the clarification of existing international law as it applies to state use of ICTs, including in relation to peaceful settlement. So one of the biggest challenges for international law is ensuring it keeps pace as the world changes. International law must remain relevant to modern challenges, to the maintenance of international peace and security, if it is to be respected and play its critical role in ensuring certainty, peace and stability in the international order. The international community has repeatedly reaffirmed that international law, and in particular the UN Charter, is applicable and essential to maintaining peace and security in the use of ICTs. The UK's national cyber strategy priorities include promoting a free, open, peaceful and secure cyberspace. And the UK's long-standing view is that when states and individuals engage in cyber operations, they are governed by law, just like activities in any other domain. We have been clear that we consider cyberspace to be an integral part of the rules-based international order. The UK has set out our view of how international law applies in cyberspace in 2 speeches by our then Attorneys General in 2018 and 2022, and in our 2021 national statement, which was submitted as part of the UNGT process. It has been positive to see more states come out and state their views on the applicable law in the area, including recent voluntary contributions made by other states, and we would encourage other states to follow suit. However, most member states of the UN have yet to set their positions out on the application of international law in cyberspace. There remains a need for states to speak up and state their positions on the law. The clearer we are about the boundaries of acceptable behaviour, the lower the risk of miscalculation, and the clearer the consequences for those transgressing them. The onus is on states to assert that there is law, to show where it comes from, and to explain what the content is. A rules-based international order can only prevail when rules are clearly understood. In the current OEWG, the provisional programme of work includes focused discussions on how international law applies in cyberspace. This focus on substantive discussions on international law is to be welcomed, and we would encourage such discussions to continue in future sessions dedicated to international law. A key part of the rules-based international order is the obligation of peaceful settlement of international disputes, as set out in Articles 2, 3, and 33 of the UN Charter. Disputes will invariably arise in the international system, and the key issue is that they are resolved peacefully and without the resort to conflict. In the cyber context, the importance of the obligation of peaceful settlement was recognised by the UNGDE in its 21 final report and was reaffirmed by states in the 2021 final report of the OEWG. The UK set out its own understanding of how the principle of peaceful settlement applies to cyberspace in our 2021 national statement, and the principle has also been addressed by the national statements of Canada, Estonia, Japan, Kenya, Singapore, and Switzerland. I'll give a brief overview of the UK's position before raising some key questions which merit further consideration in the discussions on the issue to follow, both now and in future OEWG sessions. The UK's 2021 national statement clarified that Article 2.3 of the UN Charter and the provisions of Chapter 6 of the Charter on peaceful settlement apply equally in relation to state activities in cyberspace. This means that, in accordance with Article 33.1 of the Charter, states that are party to any cyber-related international dispute, the continuation of which is likely to endanger the maintenance of international peace and security, must endeavour to settle such dispute by peaceful means. That is, negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, and resort to regional agency arrangements or other peaceful means of their choice. In terms of how this works in practice, the UK endorses the recommendation of the UNGGE in its 2021 final report in the context of the norm related to attribution of cyber incidents. There, the GGE stated that, and I quote, "An affected state's response to malicious cyber activity attributable to another state should be in accordance with its obligations under the Charter of the United Nations and other international law, including those related to the settlement of disputes by peaceful means and internationally wrongful acts. States could also avail of the full range of diplomatic, legal, and other consultative options available to them, as well as voluntary mechanisms and other political commitments that allow for the settlement of disagreements and disputes through consultation and other peaceful means." The UK welcomes that some other states have addressed the application of the principle of peaceful settlement of disputes. As substantive discussions between states develop on the application of international law to cyberspace, we think that the following issues merit further consideration. First, does the nature of cyberspace impact upon the scope of the obligation of peaceful settlement? What makes cyberspace different from other domains? When it comes to peaceful settlement, is it really different, and should it be treated differently? I do not intend to give a definitive answer to this question, but offer the following observations. The speed and often covert nature of cyber operations are sometimes said to pose obstacles to peaceful settlement. Cyber operations can take place in a matter of seconds, and the targeted state may only have a short time frame to respond to the threat. As we know, judicial processes can take a long time, as would any structured negotiation, conciliation, and mediation process. Often, states will want to respond to a cyber incident quickly. Moreover, the speed of cyber operations may make disputes fleeting and transient. That raises the question of when the peaceful settlement obligation starts and ends in this context. There may also be significant difficulties in relation to attribution, whether technical, political, or legal, including, for example, when non-state actors are involved. While these may indeed be practical difficulties which states face in responding to cyber operations, they are not necessarily limited to the cyber domain. Acts in the offline world, that's non-cyber acts by states, may also occur at short notice, giving a targeted state little time to respond, including acts which may be of a covert or kinetic nature. And difficulties with attribution are certainly not limited to the cyber realm. More generally, the underlying causes of a dispute between states, which might lead to a cyber operation, may, and often will, relate to a wider political dispute between those states, which has been ongoing for a much longer period. In such a scenario, cyber is probably one part of a wider set of tools of statecraft which a state may have at its disposal. This goes to the sometimes indistinguishable nature of cyber operations and what part of the cyber operation itself forms part of the wider dispute. In such a context, the obligation of peaceful settlement of international disputes, and in particular where a dispute is likely to endanger the maintenance of international peace and security, would apply to the wider political dispute and the various ways in which it could play out. To focus on a cyber operation in isolation in this context would seem to miss the point. Second issue of consideration, does the lack of consensus on the application of international law to cyberspace make it more difficult to settle disputes peacefully? A dispute may be economic, political, defense or security related with respect to the interests involved, but it may also have legal elements with respect to the relevant normative order that applies to those interests. So there may often be an international element to a given dispute, and Article 33 expressly references certain types of settlements where a legal framework may be relevant. Insofar as a dispute to cyber activity is framed in legal terms, then there is a risk that the lack of consensus on the application of international law to cyberspace makes it more difficult to settle disputes peacefully. If there is no common frame of reference as to the rights and obligations triggered by the dispute, then achieving a legal resolution may be more difficult. Of course, legal settlement of disputes in the cyber context may also be complicated by the absence of a clear judicial forum for settling disputes and the transnational nature of cyber operations, with the potential involvement of third states, may add additional complexity in determining the applicable legal framework. And it may, of course, give rise to issues of jurisdiction and admissibility. That said, legal difficulties may not prevent a legal dispute being resolved by other means, for example, by negotiation and mediation, and a dispute which contains legal elements may be settled without reference to legal standards, for example, if it is resolved at a political level. But the fundamental point remains. There is a risk that the lack of consensus on the application of international law in cyberspace will make it more difficult to settle disputes peacefully. There is therefore a need for states to speak up and state their positions on the law, because the clearer we are about the boundaries of acceptable behavior, the lower the risk of miscalculation, and the clearer the consequences for those transgressing them. The onus is on states to show the content of the law and to explain what the content is. Thank you, Chair. That concludes my remarks.
Thank you very much for that. And now I will consider some of the questions that we've got. I will now remind everyone in the room and our participants online, if you have any questions for the panelists, please use the Slido platform. For participants in the room, you can just press and we will give you an opportunity to ask a question. But while I don't have any questions right now, I'm going to take this opportunity to ask our panelists a question. The issue of a specialized dispute settlement mechanism came up in Professor Haj's presentation and has also been raised during this panel and I think throughout the day. And so my question then is, given the specificity of the ICT environment, should there be a specialized dispute settlement mechanism for disputes arising from the ICT activity? And I'll ask Mrs. Chanda to please share her views on that.
Thank you very much. Generally, Switzerland supports all options that are foreseen in the UN Charter in Article 33. And that would include diplomatic proceedings, and as Professor Guldig pointed out, it's quite an array, it's quite a toolbox that we have at hand. It includes arbitration or recourse to the International Court of Justice. So these would all be based on the agreement of all states involved and respect the sovereignty of all states too. It would be valuable to further explore what added value these instruments proposed by the UN Charter could have in the field of ICT, peaceful dispute settlement. And for us, for Switzerland, this should be the next step. We would start by exploring the tools that we have at hand currently. Thank you.
Thank you so much. Excellency, would you like to weigh in on the mechanism?
Yeah, because fundamentally, what we see in the UN is that there is deep mistrust and there is lack of trust because of which the available mechanisms, whether they are judicial mechanisms, whether they are diplomatic mechanisms, they don't work. And since peaceful settlement of dispute is something which is like non-binding, it's voluntary, it depends on the consents of two sides. So till the time we do not create space for diplomacy or for the present mechanisms or the articles which are available within the UN Charter to work, I think it would be very difficult to create incentive and encourage the parties to seek, sort out their differences through peaceful means. So I would suggest that, one, that the Secretary General, being the guardian of the UN Charter, should take lead, and every year should provide an international review of the situations and disputes that are on the agenda of the United Nations, especially the Security Councils, and with a particular emphasis on the parties which are in violation of the fundamental principles of the UN Charter, the resolutions and decisions of the Security Councils which are violated by parties, and which have been violated by, for the international laws, including international humanitarian law. In addition to that, I would suggest that there should also be an annual cybersecurity, global cybersecurity report, which should be identifying the major current and potential threats to the international peace and security in the arena of the cybersecurity, with a view, because we are these days talking about our common agenda, and the focus at the United Nations is to preventive diplomacy. And the focus of these reports should be to prevent and forestall such threats, including by doing the consultations among the parties concerned, calling the urgent meetings of the Security Council and or General Assembly, because we have seen lately that the General Assembly is not active in this regard. And then there should be continued increased use of good offices by the Secretary General to other countries wherever there is a threat to peace and security. Thank you.
Thank you very much. And I'm also going to give you an opportunity, Harry, to please weigh in on this as well.
Sure, thanks very much. So I would just echo the comments of my Swiss colleague, that the starting point should be the mechanisms and tools we already have, including existing international law. I think a lot of the discussion, certainly in relation to legal dispute settlement, it relates to whether there should be a specialised legal mechanism to settle the disputes. But of course, to refer to my previous remarks, often a cyber dispute or a cyber issue will be part of a wider political dispute, where it is the same issues of international peace and security that have always existed. And it's the, and these frameworks have adapted to various technologies throughout the previous decades. So I don't think that anything new in that regard is needed. To the extent that proponents of a specialised mechanism are in fact referring to some kind of multilateral attribution mechanism, I think, again, we don't think that would be necessary or desirable. It would be costly, it would be ineffective, and potentially counterproductive. For the UK, there are technical and diplomatic considerations in determining whether to attribute publicly in cyberspace, and we consider that to be a matter of policy. Each case can be considered on its merits, and we do not think there's a general legal obligation to disclose any underlying information when doing so. But again, to kind of return to the overarching point, you know, we think that the existing framework is perfectly adequate currently, and the challenge now for states is to clarify how international law applies. Thank you.
Thank you very much for that. And I'm going to come back to you again, Harry, when we talk about peaceful settlement of disputes. I think we also need to talk a bit more about what is a dispute in the context of cyber activities, and whether the Charter imposes obligations when the object of the dispute is the law, or also when the central element of the dispute features material disagreement on facts, or perhaps both.
Thank you. So I think, you know, as we've probably covered in various respects on the panel, you know, the obligation of peaceful settlement does include a range of legal and non-legal measures. As I said before, it can, you know, have various interests involved, political, economic, as well as a normative legal element to it. In the international law terms, you know, one definition of a dispute is a disagreement on a point of law or fact, a conflict of legal views or interest between two persons, and that's a kind of pretty well-known principle from PCIJ case law. That's the definition of a legal dispute. You know, could it be used to determine more generally as a criteria for when a dispute has been triggered? Perhaps it could be, but, you know, not really as established doctrine. It was certainly focused really on the legal dispute and the question of jurisdiction and admissibility. Within the legal dispute settlement framework, there has been a focus on questions of technical questions of jurisdiction and admissibility. But of course, that is not the entire picture, and international disputes can be purely political and can be settled without having recourse to legal rights obligations. So while there may be certain legal requirements in terms of judicial settlement, they don't necessarily, I think, cross over into the wider framing of settlement, of the settlement obligation. I think more generally, we consider the obligation to be one of conduct rather than result. And that, you know, states aren't tied to particular means of resolution. They can choose the means they want to pursue peace settlement by, and they don't have to exhaust them if they're not going to come to fruition. Just to add as well, I think that, you know, the Charter clearly, you know, shows an active role for disputing states as well as other states in preserving international peace. It's not limited to just the states themselves or to international courts, but you see in Chapter 6, of course, a role for the Security Council in particular. Thanks.
Thank you so much for that. In the absence of any questions on Slido, or I see, okay. I will now give the floor to the gentleman to please ask your question. Yes.
Sure. Just a couple statements. The recommendation to do a report on what the threats are to the internet is great. There's actually quite a few companies that do that now. The Verizon DBIR is one of them. It's the Data Breach Investigation Report. Worldwide contains about 24,000 different reports. So just so that the UN doesn't have to redo work that's already out there, CrowdStrike has one, Mandiant has one. There's a lot of good data out there already that shows what those type of threats are to the internet. As far as doing resolution via ISOC, ICANN, or IETF, I've done some work with the IETF, and I know the ISOC people, and they're really smart. It may not be the best place to do, you know, the adjudication of the different things, but, you know, reaching out to those groups and asking them to nominate or somehow find people that could do that, I think is a really good idea, because finding people who can opine on what the attribution is, or, you know, how we can come together to figure out who is doing this and what are the next steps to take, I think is a really good idea, and hopefully this group can move us towards that. Thank you.
Thank you. And can you please just share your details with us?
Sure. I'm Brett Thorson from BCG, Boston Consulting Group.
Okay. Thank you very much.
Thank you.
I don't see any questions from the floor, so I'm actually just going to ask my last question now, and it has to do with the principle of good faith that was also raised in the presentation by Professor. And I would like to ask my panelists, and starting with you, DPR, what are some of the expectations of the principle imposed on the states in the process of peaceful settlement of disputes?
Thank you very much. Good faith is a general principle of international law and part of the sources of international law. It is also enshrined in Article 2, Para 2 of the UN Charter and in Article 26 of the Vienna Convention on the Law of Treaties, referring to the principle of pacta sunt servanda, what I teach my kids every day. This article states in essence that the UN system can only function if all states act in good faith, and only if we can rely on this we can have predictability in interstate relations. In that sense, good faith is a prerequisite for the international legal order. Beyond a concrete dispute that needs settlement, regional organizations in particular have a crucial role to build such trust in avoiding escalation and preventing conflicts. Confidence-building measures are an important instrument to reduce miscalculation, misinterpretation, and increase transparency. The point of contact directory that is being developed in the OEWG is an excellent example and an integral element of interstate trust building. Several regional organizations have already developed POC networks and other CBMs, but they too, on regional as well as on a global level, can only serve their purpose if states actually engage with good faith. Thank you.
Thank you so much. And I'll give a last opportunity for any other panelists who would like to. Over to you, Ambassador.
Thank you. I would agree with what Chanda has just said. Just to add, the good office principle has, I would say, two sides of the same coin. One is that it has a facilitating role. It encourages parties to enter into negotiations with good intention to resolve the dispute peacefully. But at the same time, it has a restraining element as well, that the parties which are getting into peaceful settlement of disputes should not be lying, should not be using delaying tactics, and when there is a request for sharing of evidence, should be doing it based on the principle of good faith. But unfortunately, what we have seen, there are many situations which are on the agenda of the Security Council. Under Chapter 6, the parties do not see any recourse because there is no enforcement mechanism for disputes or situations under Article 6. Coming back to what you were saying, and the reports I'm talking about is with the specific reference to the situations or disputes which are on the agenda of the Security Council. A report which is produced by an NGO or any other entity which is not UN sponsored may perhaps will not be attributing the issues towards the parties which are violating in that way, which a UN report should do. And secondly, the law of state responsibility, we already know there are many challenges and gaps with that. So we are discussing these issues in a political domain. Right now we are seeing a conflict, and it is so difficult even for Security Council to come up with a resolution and pronounce that who is the aggressor and who is not. So I would suggest that given the challenges with the legal side, states are not too willing to have binding mechanisms. They do not want, like you talk about IHL Article 90 AP1. So that is not automatically applied. If there is consent, it will be applicable. If there is no consent, it's not applicable. So I think the proposal I gave is basically to create more space for diplomacy using whatever mechanism we have in the Security Council and the General Assembly. Thank you so much.
Thank you very much. Harry, do you have anything on the good faith principle?
I mean, I think, a lot has been covered by my colleagues. I mean, just to say, we would, of course, echo that it is a fundamental, principle of international law. It obviously is, enshrined in Article 2.2 of the Charter. And there is a kind of, duty there to settle in good faith. It's, on the legal side, there's a lot of commentary on this, of course. In ICTs case law, in relation to, and there's an obligation to reach agreement. They don't have to be, exhaustive if that or pursuit of necessity, for example. So, I think that those kind of principles, of course, while in the legal context, there is an underarching political foundation to it in the Charter, which I think, underpins not just the legal bits, but also the political aspects too. On the, I guess, the wider question again, my colleague referenced a specified dispute settlement mechanism. I think that, to reiterate, I think that we wouldn't agree with that. I think we think that, good faith and the obligation of good faith itself is one of the foundational tools of the Charter which allows states to settle disputes as it stands, and that should be embraced. Thank you.
Thank you very much for that. And now I'll give a last opportunity for Professor Hajar to share some views before we wrap up.
Okay, thank you so much. Maybe to add 3 or 4 observations, very general observations. The first one is that international law is based on voluntarism. So it is not binding just when the states will give the opportunity that it will be binding. If the state ratify the instrument, it will be binding. Otherwise, you are not in. So that's why, in general, international law is not very efficient because everything is based on voluntarism, on the will of the states, except the jus cogens rules, the preemptory norms that do not need any conventions. They are binding in all the hypotheses. The second observation is, I forgot to tell you that Article 33 is written in a way that it is open. So the one who wrote it is a visionnaire. In 1945, they said this is a list of means, and they finish, but any other peaceful means of their own choice. And this is really an open list. We do not need any other new text, because already the new text will be fitting under this phrase, expression. So the states can just choose any mean, or if not in this list, they can choose another one, other peaceful means of their own choice that is not in this list. So even if it was written in 1945, it is relevant till now. The third observation is the field of cybersecurity. Even if in Africa we have very good hackers, I know that. However, cybersecurity is mastered by the developed countries. So I think that there is a gap between the countries who have not the technologies and the one who master it. So all these rules, maybe we just should put some equality, some justice, so that the position of the countries who are not very well developed should be taken into consideration. Just imagine that the Third World War, I'm not optimistic, I do not want any world war, but this was a question in this morning. The next wars will not be classic wars. They will be technological cybersecurity wars on computing, on drones, on robots, on PC, etc., computers, and this is very scary. So what will be the next generation? We have a lot of very complicated positions that our countries who are not the one who put this technology will be victims. So what will be reparation? What will be the responsibility of the states in such damages? What will be the ICC, for example? Is it a crime against humanity? Is it a crime, a war crime? So maybe also we just need to think about the next steps, as you said. What will be next? We are just here together in this room. We are trying to see what are the problems of cybersecurity, cyberspace, if the existing international law instruments are occurred, are viable or not, and what next. I think it is very important also to tackle the question of reparation, the question of responsibility. Do you know that for 40 years, this draft of responsibility of the states for illicit facts is just still a draft. When I was a student, I saw it was a draft, and now I'm a full professor, it is still a draft. So also just let's be, realistic. International law is the law of the force. International law is not taking into consideration the position of the poor countries, of the ones who do not master technologies, of the ones who did not give their point of view in this very high position thinks about cybersecurity. So I think also it is very important to tackle these issues, and plus being realistic, and at the same time, I think Germany in the morning said, let's dance together, let's speak the same voice. This is our planet, this is our Earth, this is our future, this is for the next generation. So it is very important to be solidaire, to have the same solutions for the same problems and challenges. Let's just take selfishness apart, and let's be together. Cooperation, solidarity, unity, all these principles exist there. And the good faith and the intention that you will just accept the solution. While we are negotiating, we are wasting a lot of times, maybe years, and at the final point, no one is okay for the solution. So there is no good faith. So this is very important, maybe, to have a conclusion of this cybersecurity order, etc., so that we can just be inspired of what the next steps. Thank you so much.
Thank you, Professor. We are running out of time, but I'll give one last minute to you to say something.
Perfect. Thank you very much. And just building upon what Professor Guldig just said, we're having this crucial conversation today because beyond the acquis that international law applies, the concrete application of the applicable rules still need clarification. And this process of interpreting and applying the rules of international law to a particular set of facts is a common practice and a standard procedure in international law. It is important to emphasize that it does not mean we must question the rules as such. And as expressed in previous sessions of this OEWG, it is Switzerland's position, and with this I also want to echo my UK colleague, that we currently do not see the need for a legally binding instrument to fill gaps. This would be premature. Instead, as proposed in the Canadian-Swiss concept paper, we should work on developing common understandings on the application of existing international law in cyberspace. Thank you very much.
Thank you so much. Thank you so much. Please join me in thanking the panelists for their outstanding input during this session. I have been empowered to deliver closing remarks for this conference. We have come a long way since we started this morning, and while we may have introduced more questions than provided answers, we hope that at least this conference served as an intellectual icebreaker for more substantive discussions during the open-ended working group next week. Giacomo, in the opening of the first panel, described this conference as a journey of exploration and discovery, and judging by the level of engagement, both here in the room and online, we can certainly say mission accomplished. Clearly, there's a lot that remains to be discussed and agreed, but if this conference has shown us something, is that there's a widespread desire and appetite by many states to meaningfully engage with the topic of international law. And this is not something to be taken for granted in the current geopolitical context. So we are looking forward to see how the seeds we planted today will grow over the coming months in the appropriate international fora. On behalf of UNIDIR and the Security and Technology Program, I would like to thank all of our speakers and all of you for attending, whether in person or online. We would also like to thank again the Security and Technology donors that with their generous contributions allowed this conference to take place. The Czech Republic, France, Germany, Italy, the Netherlands, Switzerland, the United Kingdom, and Microsoft. The recordings of today's conference will be shortly uploaded on our YouTube channel for your future reference, and a short conference report will also be prepared in the coming weeks. We thank you again for your participation and wish you a great weekend, and hope to see you in Geneva next year for CS24. Thank you very much.